start a lawsuit. Basically, it's called commencing a claim when you start a lawsuit, and the way to do it is either by way of notice of action. That is, if you don't have all the details, you do a notice of action. And if you do, and what I prefer to do right away is a statement of claim. So a statement of claim is an actual form, and I have my books here from back in the day. This is your Rules of Civil Procedure Forms book, and it is a complement to the main book, which is this. So this is your Rules of Civil Procedure book, and every year we would get a new book given to us by the firm I was at, and it had a different color, and the different color is how you could tell that this was the new edition. There would be changes every day as the laws changed or got tweaked just a little bit. And so we get 2 of these handed to us at the beginning of every year. I guess it was our Christmas gift. Now, I don't think people use those books. I haven't pulled them out for a very long time. They're a bit dusty actually as I pull them out for purposes of this video. But you go online. It's all of online, so you're gonna put in Google Rules of Civil Procedure and Rules of Civil Procedure Forms. Now, it took me a little while to figure this out, but in the book, the number of the form corresponds to the rule number in the Rules of Civil Procedure. So if you're looking at a trial record, for example, that's going to be Rule 48 in the Rules of Civil Procedure, and the form, the corresponding form, is going to be Form 48. So everything is there for you. It's a template. Lawyers use templates for everything. So what is a template? A template is exactly what it sounds like, a template, but you have to put in the details. So you can't just rely on the template. You actually have to insert the information that is relevant to your case. So each claim is going to have a different court file number that will be assigned to it by the court. So once you've drafted your statement of claim with all the details, you are going to have it issued at court. And then you've got a live lawsuit. What is issuing at court? So you have to pay the court filing fee. So in Ontario, there is a fee schedule, and it changes, it updates I think almost every year there's changes. And they release the new figures, but they usually keep the cost of something the same for a little while and then they increase it. But you should look at the beginning of every year just to see if there's any changes to the fee schedule, the court filing fee schedule. And so when you go to issue it, you have to pay the corresponding fee, and then they're going to assign a court file number to it in the top right-hand corner, and they're going to place this seal on the left-hand side, on the top left-hand side. Now, back in the day, this would be a real seal. I actually saw that when I first started working. It was this red seal just put onto the document, like a little sticker seal. And so over time that changed. It became a red stamp that was sort of rubber stamped on. And now we have electronic filing and issuing. And so it's issued electronically, and there's an, I guess, electronic stamp, but just black and white. You then get it emailed by the court now, and then you have 6 months to serve the claim on the defendant. You've got plaintiff is who starts the lawsuit, who initiates the lawsuit, and you have defendant, who you are suing. They have time prescribed by the Rules of Civil Procedure to respond to the claim. That time is 20 days. Nobody is getting you a defense in that time period, I can assure you. And you're gonna let it go because it's more of a pain to note them in default, which is tell the court, nobody defended this, we want our judgment. It's more of an issue than to bring a motion to remove the noting in default, lift the noting in default, and so it's better just to try and get someone to defend this. If you have sent a notice letter out before suing individuals or companies, then maybe you've already had some contact with either an insurance adjuster or the defendant themselves, and you can send them another notice, either email, however they contacted you, email or calling or writing to them saying, please send us a defense by this date to avoid being noted in default. If there is an insurer, I can assure you they will respond by that date because they think there are repercussions to them. Well, not I think. I know there's repercussions to them if they don't. And then you're going to get your statement of defense oftentimes they may not have all the details yet to defend, being the lawyer on the other side, from their client, being the defendant. So they will send us a notice of intent to defend, basically saying, hey guys, we are on the record, we are defending this action, can't notice in default now, so we will get you a statement of defense. And then I usually take it upon myself, once I know who opposing counsel is, to say, hi, great to have a file with you again. How are things going? By the way, I need a defense by such and such date. Now, some lawyers use the 30 days, 60 days, 90 days. I prefer to give an actual date because saying 30 days, 60 days, 90 days can be open to interpretation. Is this calendar days? Does this include holidays? I don't want to deal with all that. I don't even want to count how many 30 days or 60 days are. So I'm just going to say, I would like this served by September 15th, 2023. And I've actually had lawyers write back over the years, a couple, not many, but a couple have said, oh, that's a Saturday. And I'm like, okay, so then get it to me by the Friday before or the Monday after. But, it's an unnecessary exchange. And that is how you start a lawsuit.